When American journalists, broadcasters, and politicians refer to Sharia law, it often sounds like they're referring to a big book of rules, something you could check out of a library, flip through, and then find the right entry for getting married or waging war. In fact, there is no such book, and there never has been. Islamic law is not a big book of rules. It is, instead, both a process and a social institution. Many, perhaps most Muslims, strive to live a life in accordance with God's will. But there has always been vigorous debate over what exactly that will entails. Sharia, the Arabic word that we translate as law, also means road or path, and refers to the path of life lived in accordance with God's will. Over the course of the 8th and 9th centuries, elite Muslim scholars decided that God's will was, ultimately, unknowable. But they agreed that God had given his believers certain clues that they could use to figure out how to best live their lives. These clues include the Quran and the Hadith, which are collections of everything that Muhammad said. Legal scholars also developed a specific and complex process for examining these sources in order to determine answers to questions facing their communities. This process is known as Islamic jurisprudence, or fiqh. The answers, or specific legal rulings, were called fatwas. A scholar who issues a fatwa is known as a mufti. In the classical system, any Muslim who had a question about any aspect of their life could send that question to a mufti, who could then answer their question with a fatwa. There are two things that I would like you to remember about these rulings. The first is that they were non-binding. Legal scholars had no way to enforce their understanding of the law. Only the ruler of a territory had the power to enforce law, and the legal scholars could only advise the rulers. This meant that any person was completely free to ignore a given fatwa or to ask for a second opinion from another legal scholar. Second, the scope of these rulings was vast and encompassed all possible areas of life, including those areas that many people associate with morality. Thus, in addition to opinions about how to get married and divorced, the rules for buying and selling goods, and the penalties for various crimes, fatwas also covered topics such as how to treat your parents and neighbors, the appropriate reasons for giving someone a gift, and the kind of intention you should have in your heart when you pray. They also encompassed devotional and everyday practice, including how and when to pray, to fast, or to go on pilgrimage, when you should bathe, what kinds of foods you should eat, and how often and when you should sleep. For many Muslims, law is something they practice at every moment of every day. When they eat and sleep and pray, when they go to work, spend time with their family, or take care of their friends, they follow a path, a Sharia, determined by law. In the pre-modern period, this system was flexible and non-binding and adapted easily to the cultures and conditions of the people asking questions and those who produced the answers. For example, in the pre-modern Ottoman Empire, each district had a judge, or qadi, whose authority derived from the ruler, the sultan. People living in each district could bring complaints before the judge, who had the power to make and enforce decisions, but had no authority to interpret the law. If a judge felt that a particular legal issue was unclear, he could consult a mufti, who would issue him a non-binding fatwa. Both the plaintiff and defendant could also consult their own muftis and come to court armed with their own fatwas. From these various fatwas, the judge would issue a binding verdict. This process changed drastically over the course of the 19th century, when France and Great Britain colonized and ruled many Muslim-majority territories in Africa and Asia. The French and British required their Muslim subjects to do something that they had never done before. They were forced to codify their laws, to write down a definitive list, a book of rules. The French and British governments then used these codified law books in special courts that they set up for their Muslim subjects. We can still see the effects of this codification of Muslim laws under colonial rule. Over the course of the 1940s, 50s, and 60s, Muslim-majority states freed themselves from colonial rule and established independent nation-states. Most of these new nation-states borrowed heavily from French or British laws when they drafted their own constitutions and legal systems. The laws of many Muslim-majority nations, such as Egypt, are based on either French or British criminal and commercial law. Over the course of the colonial period, generations of Muslims were also raised with an understanding of Islamic law as a book of rules, a fixed set of regulations and punishments. As a result, when certain Muslims today want to govern a nation or a territory according to Islamic law, they are usually referring to a codified version of one interpretation of the law. Most Muslims around the world acknowledge the authority of the state to make and enforce the law. This holds for people in Muslim-majority countries, as well as for Muslims who live as religious minorities in countries like the United States. No part of the United States legal system is based on Islamic processes or institutions. For American Muslims, the classical Islamic legal system plays no role in determining crimes or criminal punishments. These Muslims may still turn to muftis with questions about how to pray or how to deal with an unpleasant neighbor. Some Muslims in the United States will also enter into marriages and divorces according to the principles of Islamic family law. The state does not recognize these religious marriage contracts. If couples want the state to recognize their marriage, they must also obtain a civil marriage license in accordance with federal marriage laws. This means that a couple might be considered married according to their Muslim community, but unmarried according to the state. The reverse is also true. A Muslim community might still consider two people to be married, even if the state has granted them a divorce. The process and institution of Islamic law may seem complex, but it is no more complex than the legal system of the United States. Fully understanding either system usually takes years of dedicated study. Ultimately, I want you to remember that all law is based on both interpretation and authority. Think about the system of law that governs your life. Who interprets that law? Who enforces it? And what is the source of their authority?